Good afternoon, everyone. I am Blessing Adekombi, a member of Group 1, and we are here to discuss the elements of a valid trust. But before then, I would like to define what a trust is. Professor Keating in Law of Trust, 9th edition, defined trust as a relationship which arises wherever a person called the trustee is compelled in equity to hold property, whether real or personal, or whether equitable or legal title, for the benefit of some persons called the beneficiaries, or for the benefit of some objects permitted by law.
We have two types of trust: express trust, implied trust. Express trust is created by the acts of the owner of the property, either inter vivos or by will. When we talk of implied trust is created by the presumed intention of the owner, e.g., where there is a failure of express trust.
With regards to the essential elements of a valid trust, we have three certainties. We have the certainty of intention or words, we have the certainty of subject matter, and we have the certainty of object. With regards to certainty of intention or words, when a testator is making an express will, he or she must make use of imperative languages, and his words must be clear, must be concise, must be certain, and must not be ambiguous. He or she must not make use of precatory words.
First essential element of a valid trust is capacity. Parties must have legal capacity to create a valid trust. Parties must either be adults or people of sound mind. A person of unsound mind or an infant does not have the legal capacity to create a valid trust.
One of the three certainties that makes up a valid trust is the certainty of subject matter. The property or subject matter must be clearly identifiable, otherwise it will be void.
This is certainty of subject matter. It's a case of voice versus voice, where the testator left 4 houses to his 2 daughters, under the condition that his eldest daughter will pick 1 house and the remaining houses, 3 houses, will go to the second daughter. However, the eldest daughter died before she could pick any of the houses, and it was unknown which houses she would have picked. So the court held that there was no valid trust created, as the subject matter of the trust was not ascertained.
In the case of Musori Bank versus Reno, the testator wanted to give his property to his wife using the statement in full confidence that she would have to just leave to her children in dividing the same when it is no longer required by her. Also, we have the case of Snowden, where the testator used the statement, "I believe that he would split the property rightly between my niece and my nephew." These statements do not show the certainty of the intention of the testator to create a trust, and therefore such trust cannot be valid.
Exception under the certainty of intention. Exception under the certainty of intention is the examining of the old document to determine the intention of the testator. In some instances, the court may look into the old document. In the case of Kominsky versus Boring, it was said that there was a valid trust because the testator intended to leave it as a gift to his wife. While in the case of Lambert versus Ames, there was no valid trust, as there was no certainty of the interest allocated to the
Branch and Bernard, where the testatrix left properties for her husband and also gave that whatever he didn't want for himself should be held on defining trust. Now, this trust was held to be too uncertain. In another case where subject matter was held to be uncertain was in Palmer and Simmons, where the testatrix also left the bulk of her estate to be held on certain trust. However, this trust was too uncertain due to the expression bulk of her estate.
Certainty for the creation of a valid trust is the certainty of some object matter, that is, the beneficiaries must be identifiable or be able to be identified and also ascertainable.
In the case of Morris versus Bishop of Durham, and question left £30,000 on charge of the executor Barity, the Bishop of Durham, to be spent on such object of benevolence and liberality as the trustee in his own discretion shall most approve of. However, the wedding in this gift was vague and unspecific. After Anne's death, his cousin William and Anne sued, claiming that the gift was too uncertain to be considered valid. The court held and ruled that for a trust to be valid, it must give a broad discretion to the trustee on how the money is to be spent. Therefore, the money was taken back and given back to the next of kin of the Morris.
Concerning the essential elements of a valid trust, if there is uncertainty as to the words used, the trust fails and the donee takes beneficial interest, if there's no certainty as to the subject matter of the trust property, the trust fails and the donor takes beneficial interest. If there's no certainty as to the beneficial interest of the beneficiary, the trust fails and the trustee holds it in a resulting trust.